charges in Ngumi against the Attorney General of the Bahamas and 3 others.
Yes, Mr. Smith.
Good morning, my lord. Good morning, my lady. Good morning, my lords. I appear for Mr. Ngumi along with my friends from the English and Welsh Bar, Miss Ruth Jordan and Mr. Thomas Elias. And with me from the Bahamas Bar are Mr. Roderick Dawson Malone, Miss Candace Maycock, and Miss Raven Rowe. And for the respondents, Mr. Robert Strang, and along with them from the England and Welsh Bar, and Miss Kenria Smith from the Bahamas Bar.
Thank you. A formidable team.
Formidable, my lord. Thank you. So, my lord, I bring you greetings again from the Bahamas, because the Bahamas seems to have had a lot of cases before your lordships recently. And on this occasion, we're bringing you some nice Bahamian weather. It's very sunshiny outside. So I hope it stays this way for you.
I'm sure the fog that was rising from the river this morning.
Yes, no, we did bring that one.
Tinge to it.
So, my lords, I had sent in a speaking note
Yes,
yesterday.
we have received the speaking note.
Yes, my lord.
I have to tell you, Mr. Smith, we received it without thanks. Let me explain. The rules are quite strict about the length of written submissions, which of course applies to the parties' cases.
Yes.
And it's to those written submissions that, for example, your opponent, Mr. Strang, has to reply.
Yes.
He has obviously he gets time to prepare to do that under the rules. The effect of putting in a speaking note on the morning of the hearing, quite apart from the pressure which it would put the board under if we pre-read it, and I make it quite clear I have not pre-read it, is partly that it puts pressure on the respondent to respond to it at a time, what is likely to be, to put it at its lowest, an inconvenient, if not impossible, time frame. But also there are those of us who prefer an oral hearing to be a genuinely oral hearing and to take in their own fair hand or on their own fair laptops such notes of the oral submissions as are made, so that the hearing is a proper exchange of oral submissions. We do make it clear that we don't encourage these speaking. I'm sure they were submitted with the best of intentions to save our pens, but I'm afraid pens or laptops are the order of the day, and you should not assume that your speaking note will be read even later, and Mr. Strang should not feel under any obligation to respond to it. That said, I'm sure it will help you, and we will enjoy hearing your oral submissions.
I understand. I had proposed to do it only orally, but having seen the number of points, and I know that no case is bristling like a porcupine with multiple points in which there are some main points, but our time is quite limited.
Yes.
Perhaps we should have asked for more time, but it is a rather important case, so I thought it helpful to put it down on paper. I wasn't seeking to take Mr.
I'm
Stein
sure you weren't.
by surprise or ambush in any way. And it is a synthesis or a summary extract of our case, our written case. And you'll see that it's actually, there are lots of spaces between the, so although it's long, it's not actually that long.
Yes, well, don't make any assumptions about what we will see.
No, no. And so I can go straight to the first ground, Lords, which is, I think, a point that is extremely important for the Bahamas, because as a result of it, the first point, the first ground, is that there seems to have developed a sort of presumption of reasonableness on the part of the courts, both at the Supreme Court and at the Court of Appeal, to simply say, well, immigration have 3 months within which that's a reasonable period, regardless of the facts of any particular case, to hold a person pending deportation. That was a surprise ruling from Her Ladyship Justice Charles at trial. That was not something that was pleaded or argued by the defendants at trial, and we sought to challenge it at the Court of Appeal. And the Court of Appeal simply adopted what they thought were the principles outlined in Takitota at the Privy Council, and also the Hardyal Singh principles, Tanti Lam also, the case of Tanti Lam, to say that as a general proposition, 3 months is a reasonable period for the immigration authorities to attempt or make arrangements to deport a person that has been arrested. And what is particularly egregious in this case is that the judge did not find, and specifically ruled, that there were no facts upon which the measure of reasonableness could have been determined.
Have I correctly understood that there is no evidence before us in documentary or other form to suggest that anything actually happened in that 3-month period?
That is correct, my lord. And in fact, counsel for the respondents in the Court of Appeal, and I'll take your lordship to it, specifically conceded that before Sir Michael Barnett when she was questioned on it. And Tanti Lam and Hardyal Singh and Kaczynski, I think, Kambadzi, and Lumba. Lumba and Kambadzi took me 6 or 7 hours to read. I didn't have the app that my friends have to try and go through it quickly. Those cases go into a huge amount of detail as to identifying the facts and circumstances that are relevant in each case to determine what period of time would or would not be reasonable to make arrangements to deport or to detain someone pending deportation.
Yeah, I mean, it seems quite clear that there isn't a fixed period. It's basically a public law doctrine that you, as the authority, have a reasonable period in which to take steps to deport someone. Yes. It may be longer than 3 months, if that's what it takes to sort out the situation with the foreign country where they're to be deported. But the predicate for any time at all is that steps are being taken to make those arrangements. You can't sit on your hands as the authorities.
That is correct. And there's one case I would also just mention to your lordships. It's the case of Martinez, a judgment just issued out of Trinidad by your lordships, by the board. And that's to be found at EB, supplemental binder 730.
Sorry, what do you mean EB supplemental?
The electronic binder. I'm giving you the case reference number.
Right, but in
the supplemental authorities bundle?
It's in the authorities bundle.
But we've now got, I think, 3 electronic bundles, so we need to know which one.
It's the one that says EB supplemental.
Yeah. What page was it?
Supplemental.
It's a 730. And that's the reference to the beginning of the case.
Martinez, yes.
And the specific reference...
Just let me get that.
Sorry, look.
Right.
And which paragraph do you want to say?
And it's specifically at paragraph 753.
You mean page 753?
Page 753. Yes. Yes, it's at the top of the page. At paragraph 83, and quote, the board notes that one of the Hardyal Singh principles is that the deportee may only be detained for a period that is reasonable in all the circumstances. All the Hardyal Singh principles should be seen in their context that their purpose is to protect personal liberty. Furthermore, it is for the court to assess for itself the reasonableness of the period of detention. The assessment is informed by case-sensitive consideration by the court. and I might pause there to say, not a broad brush license to the immigration department to simply hold people for a 3-month period. A presumption of reasonableness. Sorry, the assessment is informed by case-sensitive consideration of reasonableness in all the circumstances, with each case requiring a value judgment by the court. A presumption of reasonableness undermines the purpose of the Hardy-Alsing principles, which is to protect personal liberty, and diverts from the court's judgment on the particular circumstances of the individual case.
But your proposition is a straightforward one, that anyone seeking to exercise a power of detention must take all reasonable steps within his or her power to ensure the removal within a reasonable time. And if one doesn't take any steps, then one isn't behaving reasonably.
That's correct.
That's your submission.
And where my friend and I believe differ is that his case, the respondent's case, is based on instances or illustrations of what he terms, or what the respondents term, to be efforts, some of them 2, 3, 4 years later, in respect of Mr. Ngumi. And also, we fundamentally differ that his case is based and premised on the minister, by delegation from the Governor General, having the power to detain under Section 41, subsection 4. And that simply is not the case. And I can take your lordship, that might be helpful.
You're moving on to a different point, I think, aren't you? I mean, you're moving on to the vires of the detention rather than this point about what is a reasonable period. Just so we know.
Yes, I am, my lord. Anyway. But I've segued into it. You're correct, my lord. I had segued into it because he relies on the minister's power to detain and to order the deportation, and seeks to rely on what the minister may have done subsequently, or the minister may have presumably or indubitably took XYZ into account in holding Mr. So I'll go back.
But I mean, just on that,
yes.
in the sense, if you're right about the nature of the power, that the power to detain by whoever has to be, in a sense, justified by steps being taken. If you're right that no steps were taken, and therefore it couldn't be justified, it doesn't actually matter who had the power. I just want to see how the arguments fit together. I mean, by all means, take up time on that, because this is an argument you're presenting, and it might not succeed. But just at the moment, it seems to me that if you are right on that point, in a sense, it doesn't really matter who had the power. No one was exercising it.
I believe that's correct, Lord.
Okay.
It is, but it is a point of continuing importance in the Bahamas as to who has that power, because in 1981, there's the Jean Charles case, which I will take your lordships through very, very briefly. And in 1968, there's the Marie Taylor, both habeas corpus cases, which I will take you to. And in this case, the deportation and detention order in 2001, I think, in respect of Mr. Ngumi, they continue to use the same form, and they continue to insist that, or the government continues to insist, that the minister is able to exercise such power to deport under Section 40, which the minister has. And I'd like to take your lordships to it.
Might I just ask one other question, please, before you do that? As I understand it, your first submission is that one must take steps for any time at all to be reasonable, whether the power exists in whose hands it may lie.
Yes.
Does it make a difference whether or not, if steps had been taken, it would nevertheless have taken more than 3 months to effect the deportation?
It's fact sensitive to each case, I would submit, my lord. If indeed the government could show that they were actually making efforts and it took longer than 3 months.
That's not the case I'm putting to you.
Sorry, my lord.
The question I'm putting to you is, assuming nothing was done, but supposing something had been done and the evidence shows it would have taken more than 3 months, does that justify the detention even though nothing was done?
And I would submit that it doesn't, my lord, because then one would turn to whether or not the detention was lawful in the first place.
I think it's inherent in your submission, isn't it, that you've really got to look at this. If the respondents say, well, actually, there were times when we were doing something, you've got to see whether that made the detention lawful at any particular moments in time, and then, if necessary, add them together. It's not enough to say, well, there were 7 years and we can knock off 3 months because reasonable steps might have taken 3 months.
That's correct. I would agree with that.
You say it's a fact-intensive, possibly quite time-consuming and sleeve-rolled-up job to work out what, if any, days or weeks were times when the detention was lawful because during those periods something of the requisite type was happening. I think that's what you're saying.
I do believe that's correct, my lord.
Yeah.
Yes.
So the reason I was focusing on the 3 months period is because, as I understand it, you're making your submissions on the basis that the 3 month period is of particular importance as a matter of principle, not just for this, but for other cases
Other
too.
cases, my lord, yes. And that later feeds into my submissions on constitutional or exemplary damages. Because notwithstanding judgment after judgment after judgment of the Supreme Court, Court of Appeal, and Privy Council, all paying great service to the liberty of the subject and how sacrosanct freedom is in the Bahamas, the executive just is not listening. And there are just many, many, many cases that on the same facts. And as I will also be submitting later in this case, your lordships will see that there was he was released when we issued a habeas corpus with no resistance, and
In a matter of days.
within a matter of days. And then the defendants in the lower court defended the case when there was nothing that they could have defended on the basis of liability. As in the Amishir case, which I can take your lordships to later, they thankfully admitted liability and the consent judgment was entered, and we then went straight to assessment of damages. But Mr. Ngumi was subjected to nearly 3 years of all of the cost and expense and challenges in pursuing a case and being out of his money. And to this day, there has been no payment by the respondents to Mr. Ngumi, either by way of interim payment, which we sought, or payment of the judgment damages.
Sorry, I was diverting you from your next point.
So
You're going
So could I take your lordships to the Immigration Act? I think that would be a helpful start, because that is the foundation of this entire issue. It's to be found in, there's a key documents bundle, and it's at page 1028. It's, sorry, no, the Immigration Act isn't in the key bundle. It's to be found at EB 1040 to 1041.
Yeah.
Do your lordships have it?
Yeah.
I can never tell because I'm not as accustomed to the computer. I don't see pages flipping. So, Lords, at page EB 1040, we see section 40 of the Immigration Act. And the relevant portion of it is, well, it starts in paragraph 1. If at any time after a person other than a citizen has landed, or it shall come to the knowledge of the minister that such person, and the relevant portion may be subparagraph B of section 1, and C. Those two may be in play according to the respondent's case. The minister, and I highlight, the minister may make an order referred to as a deportation order, requiring such person to leave the Bahamas within the time fixed by the deportation order and thereafter to remain out of the Bahamas. And the next section, you see the side note, which refers to removal of persons.
And sorry, just before we move on to the next
Yes, sir.
section, just on the facts, I haven't looked it up, but in September 2006, there was a letter saying that Mr. Ngumi should leave, that he no longer had permission to remain. Would that be what is called here a deportation order?
If I could take your lordship to an example of the deportation order that was issued against Mr. Ngumi, and that's to be found at EB.
Well, I'm keen not to divert you from the submission of law, so by all means come back to that. I just wanted to check.
And so section 41 of the Immigration Act provides that, subject to the provisions of subsection 5 of this section, any person in whose case a deportation order has been made may be placed under the authority of the Governor General on board a ship or aircraft about to leave the Bahamas, etc. The relevant subsection is subsection 4. In subsection 4, it has two limbs. The first limb is subject to the provisions of subsection 3 of this section. Any person in whose case a deportation order has been made may be detained under the authority of the Governor General until he is dealt with under subsection 1 of this section. That is the first limb, and that, we submit, refers to a deportation order that may have been made by the minister under section 40, either in the exercise of powers under A, B, or C. Now, the second limb, importantly, a person in whose case a recommendation for deportation is in force under section 40, unless the court, in a case where the person is not sentenced to imprisonment, otherwise directs, be detained until the Governor General makes a deportation order in his case or directs him to be released. So there are two distinct entities that have the power to make a deportation order. Under section 40, it is the minister, and under subsection 4 of section 41, it is only the Attorney General. And for this purpose, because I've summarized this, if I could, with your leave, my lord, take you to the speaking note so that I could refer you to the two cases that are relevant, it would make it simpler.
Well, just cite the cases. I'm not proposing to use your speech.
So the cases are, yeah, I'll find out in a second. So the first case, which my friend relies on, is the case of Xavier versus Minister of National Security. That's a 1986 case, and it's referred to at EB 1290. In that case, Justice Gonzalez-Cibola, as he then was, sought to validate, and it was only obiter, as we point out in our case and in the speaking notes. He was attempting to validate and save or reconcile what he considered the apparent differences between section 40 and section 41, subsection 4. But subsequently, in the two cases...
Do you want us to go to a particular paragraph in this Xavier case?
I didn't hear you, my lord, I'm sorry.
Would you like to refer us to a particular paragraph in the Xavier case?
Sure. Yes, my lord. It's 1290.
25.
24
to 26 of page 1290.
Is it 25?
24 to
1293.
1294.
So the relevant paragraphs, my lord, which the respondents rely upon, start at EB 1293, paragraph number 24.
Yeah.
And that's why we say it's obiter. His lordship says, I now make a general observation, and he goes on to refer to what was then section 37.4, not 41.4 of the Immigration Act. And he says, some clarification of this provision is necessary. Grammatically, it is referring to a recommendation for deportation in force under section 36. But section 36 does not contain any provision dealing with recommendation of deportation. No other section does. The difficulty with the phraseology of the draftsman presents is, however, relieved by the construction necessary to interpret the words ut res magis valeat quam periat. The only way in which effect can be given to this maxim consistently with the apparent intention of the legislature is to transpose the phrase, quote, is in force, unquote, to follow the phrase, quote, under section 36, unquote. And he indicates that he follows the judgment in the judgment in Lyde and Barnard. And then he goes on to say, in the last sentence of paragraph 25, in section 37.4 of the Immigration Act, what occurs is an apparent misprint in an act of Parliament, which a court of law has jurisdiction to correct in the course of its functions of interpretation. And so he then says, so reading section 37.4 with the transposition made, it is mandatory on a recommendation of deportation being made and the court not directing otherwise for the convicted defendant to be detained until the minister makes a deportation order. The significance of the circumstance, the rest of that.
He's speaking presumably of an earlier Immigration Act, or at least an Immigration Act in an earlier drafted form.
But it's in identical terms,
But
other than the different
What
numbers.
he describes as the typographical error has been carried through in its real.
Yes, yes, my lord.
Yes.
And I don't think that when we're dealing, I think the authorities are quite plain when we're dealing with the liberty of the subject. They must, any provision being relied on must be very strictly construed. And we say, firstly, it's not a misprint, and where is the case? We say that when one looks at section 40, subsection 1, and in summary, as is in our case, it is only possible for that subsection 4 of section 41, which refers to a recommendation, to possibly, and we don't admit that it does, but to possibly have effect by way of a recommendation, not by a court, but under section 41, subsection C, is that the board itself may perhaps come to a decision about a particular person whose presence in the Bahamas would, in their opinion, be undesirable and not conducive to the public good. And then the minister makes a deportation order.
But don't the words in brackets suggest that it's referring to the court? The court which has convicted the individual of an offence punishable by imprisonment for 2 years or upwards.
Yes, lady.
And it would make sense, wouldn't it, in those circumstances, for it to be referring to the court, because a power of detention in circumstances where the person has been convicted is to be expected.
Several points to that, if I may, lady. Firstly, a magistrate's powers are severely circumscribed by statute.
Well, they're statutory. They have to be in the statute,
Yes.
either expressly or impliedly.
Okay. So when we go to the Magistrates Act, or the Penal Code, or the Civil Procedure Code, or the Police Act, or the Criminal Procedure Code, nowhere is there any statutory authority for a magistrate to either recommend or to sentence for deportation. And in this case, we say the magistrate didn't even recommend. The magistrate actually purported to sentence. And I think it's important.
Well, just on the point of law, I mean, one might say all the more reason, since these powers which one would generally expect a court dealing with someone who's been convicted of an immigration offence to have, all the more reason to construe what is in section 41(4) as comprehending that sort of power, because it's nowhere else, as you emphasise.
Yes.
Sorry, yes, you're agreeing with that one would expect it to be in section 41(4).
Lord, something has gone wrong here.
Right.
But we're bound by the strict terms of the statutes.
Yeah. Well, we're bound by the statute as properly construed.
Yes, yes, my Lord. And there is, and it would be important at this stage for your lordships to see what, in fact, the magistrate purported to do. Where is that?
Just before we do,
Yes.
Are you moving away from section 40?
No.
Because at some stage, it would help me to see what are the provisions in the Act which provide for sentence for a conviction of an offence against this Act.
And that's what I was going to take you
Okay,
to.
fine.
So, Mr. Ngumi, and that is to be found. What it is. So, I'd like to take your lordships to the actual charge sheet so that you can see what the magistrate, in fact, did.
It was an offence punishable by 2 years
Yes.
or more, wasn't it?
Yes.
Yeah.
Yes, madam. So it's at EB 598. There are two charges there. That's the charge sheet upon which Mr. Ngumi, we say, was not convicted. And I'll explain that in a moment.
Sorry, just on the 2-year point, looking at section 41(b), in fact, because these, I think, are offences against the Act, against their immigration offences, they didn't need to be punishable with 2 years or upwards. And looking at section 41(b), there seems to be two limbs. Either it's an immigration offence with no particular sentencing problem, but one could readily understand that if you're overstaying without leave, that's an immigration offence, that ordinarily there would be power to detain you, to remove you, because that's what's supposed to happen under the Act. Or it's a particularly serious form of criminal offence, which it's almost like deeming you to be your presence in the country to be not conducive to the public good, and that's a separate basis.
Yes.
That's just checking I've understood correctly.
I agree with that, Lord. But as a precondition to the detention would be the lawful exercise of the power by the minister to first issue a deportation order under the last part of section 40.
Or a recommendation. You said there were two limbs in 41(4). One is pending a deportation order, and the other is pending a where there is a recommendation pending the deportation order.
But then,
But sorry, I'm sorry to pick you up on this. It's not a precondition that the minister's made an order, is it? No. So you might have overstayed. You've been picked up by the police, as Mr. Ngumi was, as an overstayer. You're prosecuted and found guilty of overstaying. So you're before the court. They've convicted you. You've been convicted of an offence against the Act, so that gives the minister a power to make an order for deportation. But at the same time, there is the distinct power under section 41(4) that there may be a power of detention under the authority of the Governor General. And then you have the second limb of section 41(4) that, depending how one construes it, that if the court has recommended that you be deported, then a mechanism is put in place that you're detained pending deportation, but of course the deportation mechanisms then have to operate. But I'm not sure that it's a precondition.
I think I agree with you.
All right, okay, fine.
I agree.
Okay, sorry to go on about it.
But when we come to subsection 4, it is then a detention, mandatory detention, if there was a conviction and if there was a recommendation under the second limit of subsection 4.
Mandatory detention unless the court otherwise orders.
Correct. But it is then not to detain pending a reasonable period for deportation under the second limit of subsection 4. It is until the Governor General makes I'm going to insert the word, makes a decision to make a deportation order. That's the relevant period.
Well, it may be
Or
both.
release him.
Maybe both. But why is it just one or the other?
Well, because the power, the detention under second limit of subsection 4 provides a mandatory detention if someone is recommended for deportation. And he shall be detained until the Governor General makes a deportation order. So the period that one would look at is not the period that they are arranging for his deportation, which is the error we say both the judge and the Court of Appeal fell into. It is until such time as the Governor General either releases the person or makes a decision to make a deportation order. Yeah. And that period, we say, is a matter of days. My friend has suggested, I also, and I agree, is that it is because there is no deportation order that it is sequential.
The odd thing is that Lim 2 comes first in the sequence.
Yes.
So the recommendation is made, the person in question is detained until the Governor General makes a decision. If the Governor General makes a deportation order, then that person is detained under the first limit,
Yes.
pending deportation, but within a reasonable time.
Yes.
But you say in this case there never was a deportation order, at least not by the Minister or the Governor General.
Or the Governor General.
All there was one by the magistrate.
Well, a sentence by the magistrate. If I could take your lordships now to page...
Well, I'm so sorry, just trying to get the mechanisms right. Is this right, that section 41(4), the second limb, could be contemplating that two things have to happen. One is, if this is right, that the person's before the court, let's say the court makes a recommendation for deportation, but at the moment there is neither an order for deportation under section 40, subsection 1 by the minister, and therefore, or at any rate, nor is there an authorization of detention by the Governor General under the first limit of section 41(4). So one possible reading of what happens is contemplated by the second limit of section 41(4) is that the court makes a recommendation, but then, and that authorizes someone to be detained while the other two mechanisms are brought into play, because you need both the making of a deportation order by the minister under section 40, subsection 1, because the Governor General under section 41(4) can only make his authorization of detention if there is a deportation order, and then you need the authority of the Governor General to detain. Is that right?
So subsection 4, I'm just going to read that again more carefully. Subsection 4 provides that Any person in whose case a deportation order has been made.
Right, so
that must be
stop
section
there.
40 subsection.
Yeah, so that's something that needs to happen before
Yes.
someone can be detained on the authority of the Governor General, is that you have a deportation order made by the Minister.
Yes.
Okay.
Until he is dealt with under subsection 1, which is to put him on the boat, which suggests a rather immediacy or an urgency to the situation. It's not that you just hold someone for 6.7 years with no efforts to try and deport him. But the second part, my Lord, is a person in whose case a recommendation for deportation is in force under section 40. And there is we submit, the only possible way that a recommendation could arise under section 40, because section 40 doesn't speak of a court in any way.
Well, it does. Section 41B talks about a court,
About
implicitly.
About a person being convicted.
Yeah.
Yes, right.
And then section 41.4 uses the definite article, the court. So that must be contemplating that a court is there in operation in some way, isn't it?
And it's also talking about a case where the person is not sentenced to imprisonment.
Yes, I see that under the second limb.
Yeah.
Yes, we're talking about the second limb.
But there is, lady, nothing. We were simply trying to find some way of. There's nothing in section 40 which speaks to a recommendation at all. It simply is not there. There's no statutory reference in section 40 to any recommendation. And the court, this is where I'm making the subsequent submission, that the court has no power, the magistrates' courts have no power, in this case it was a magistrates' court, to recommend deportation or to sentence for deportation.
Well, unless it can be read in the statute, either expressly or impliedly.
Yeah.
In the Magistrates Act.
No,
in this act.
In this act.
That's, as I understand it at the moment, that's the whole point of the interpretive argument about section 41.4. It's being said that one gets out of this act the power for the magistrate, admittedly by implication, because it's not spelled out, but by implication, a power for the magistrates' court, when someone is before them being sentenced, to make a recommendation for deportation.
Yeah.
But, my lords, I am submitting that if the magistrate did perhaps have such a statutory power, that leap could be made, or that interpretation could be contemplated. But when one looks at the Magistrates Act and any other act...
We're saying, we may not be right, but what we're putting to you is, put out of your mind the Magistrates Act. You get from this act, by implication, the power for the Magistrates' Court to make a recommendation for deportation. That's where the statutory power comes from.
That's not so surprising. In the domestic legislation here, the Immigration Act provides the power for recommendations.
And just to add the last point, which we have made with you already, the fact that there's nothing else in the Magistrates Act, the Magistrates Courts Act, could be said actually to reinforce the interpretation that we're now putting to you, because there seems to be a contemplation that someone who's, let's take an overstay, has committed offences under the Immigration Act, is before the court, and the court is having to make up its mind what should happen. The court would, in that situation, be expected to have a power to recommend deportation of the person. Why not? They're there as an overstay. They've just been convicted by the court of overstaying. And then if the court does recommend that, the logic of the argument would be that the second limb of section 41.4, if you like, creates time while the person's being detained, doesn't disappear off, time for the two mechanisms that then need to happen for actual deportation to occur to take place. The first being the making of a deportation order by the Minister under section 40 subsection 1. The second being authorisation for detention by the Governor General under the first limb of section 41.4.
I know that your Lordship with respect.
I mean, and tell us why we're wrong. That's what we're asking you to do.
I would submit that that is not a correct interpretation, because the words are simply not there. And when you're dealing with the liberty of the subject, one must strictly construe statutes to protect the liberty of the subject.
Right.
And one cannot be importing or interpreting statutes to deprive a person of their liberty without specific provision being made, very specific provision.
Essentially, your submission is that the recommendation can only be made under section 40, subsection 1C.
By the board.
By the board. That's your submission.
If that is
good or for bad, that's it.
That's it. And
By the board.
by the board.
Yes.
By the immigration board.
I'm sorry, I haven't read the section. So where does the immigration board come in?
Section 40, subsection 1, paragraph C.
I'm not submitting that that is.
I didn't think any reliance was being placed on C.
No, we are not. We were simply submitting that a possible way of understanding the word recommendation in section, in the second limb of section 40, subsection 4.
Mr. Smith, we are asking for your submission now. I mean, you seem just to be floating possibilities. What do you positively say?
I positively say that there is no power under subsection 4 of section 41 to detain a person on the recommendation of a court.
But what do you say we should understand by the words "a person in whose case a recommendation for deportation is in force"? What does that
I say
mean?
the only possible meaning we can ascribe is to
what
possibly
C,
look at
the board.
C, 40, subsection C.
So that is your
That's my
submission.
submission.
Yeah.
And I bolster that by reference, in addition, to the fact that magistrates.
You said there's no express power in the Magistrates Act conferring a power to make a recommendation on a magistrate.
Yes.
And that's
Or to sentence. To detain pending deportation, or to sentence.
Do you need a power to recommend that some other body that has the power to do the actual thing, you need a power to recommend that other body does it? I'm just thinking, take a case where a professional person has appeared to a judge conducting a trial professionally in proper way. It's not uncommon for the judge in that case to recommend that that person's professional body has a look at the facts with a view to possibly instituting disciplinary proceedings. I don't think anybody's ever said, well, the judge had no power to make that recommendation. It's just something the judge thought was a good idea that had no immediate consequences for anybody.
Well,
I can see there are consequences here, but I'm just looking at it in terms of what, and I accept that a magistrate is a creature of statute, but I'm just really wondering whether power is the right word in the context of a judicial person making a recommendation who doesn't have a power to deport, recommending that somebody who does have a power to deport exercises that power.
well, my lord, if the result of the recommendation is to trigger mandatory detention, where the magistrate doesn't even have that power, recommending a disciplinary tribunal investigation doesn't automatically put that person in a detention center overnight, with respect.
You may pray in subsection 4 the words a recommendation for deportation is in force, which is a little incongruous with the possible construction my lord has put here.
So if I could take you to 598.
But before you move away from this, are you going to address us on the powers of the board? Just looking quickly through it, I'm trying to see whether the board has a power to recommend in the relevant sense.
There's no express provision for a recommendation by the board either, my lord. We were just trying to find some way of trying to make sense of that subsection.
Well, I think we must leave you free to move on, because we're conscious there's a lot in this appeal, and we're still dealing with the very first point.
Yes.
and only one of the reasons why there shouldn't have been a 3-month
Yes.
deduction.
Yes. So if I could quickly finish with that point and take your lordships to EB 598, which is the charge sheet.
Yeah,
And your lordships will see that Mr. Ngumi was charged with something that was only punishable under Section 49 of the Act. The consequences of punishment under Section 49 are the 2 years imprisonment or a fine. First of all, there is no, and I go into it in the papers before your lordships. There is, you will find nowhere on this charge sheet a record of the magistrate having convicted Mr. Ngumi.
But he pleaded guilty.
He pleaded guilty, but the magistrate did not record a decision of conviction. He went straight from defendant ordered deported to his homeland in Canada.
I thought it was a guilty plea and sentencing was deferred from the 18th to the 20th.
Yes, my lady.
And surely that's the significance of the note PG to count number 1, plead guilty to count number 1, PNG to count number 2, plead not guilty to count number 2.
And that charge was withdrawn.
So this is a full record of conviction on the basis of a guilty plea for count number 1.
And I would take your lordships, I would refer your lordships.
Well, first of all, is that not right?
No, with respect, it isn't right. It's not a conviction, Lord. And the magistrate had no power to sentence.
I'm sorry. How is that not a conviction? Someone is before the court, pleads guilty.
Because the Magistrates Act, my lord, at section 108, and there are several cases in the Supreme Court and in the Court of Appeal of the Bahamas that have found repeatedly that if the decision to convict is not expressed on the record, there is no conviction. And either the conviction, purported conviction, and the sentence is then set aside, and or it might be remitted to the magistrate. Those two cases are to be found. The case of Taylor versus Commissioner of Police.
Well, first of all, I'd welcome your assistance as to why the magistrate recording PG to count number 1 is not a record of a conviction.
Because, my lord, at section 108 of the Magistrates Act, and I'll read it, it's to be found at EB Supplemental Authority, pages 5 and 6. But the short summary of it is found at paragraph 31 of my speaking notes.
Yeah, which I've already told you I'm not looking at.
Okay. Well, at Taylor versus Commissioner of Police, EB Supplemental Authorities 521, an appeal was allowed because of the non-compliance of the magistrate with section 105(1) of the CPC.
Was this point taken at any stage below, that there wasn't a conviction?
No, my lord.
That you're taking this point now for the first time before us, on the basis of a speaking note?
I am, my lord.
Is it appropriate to ask permission to take a point like this at this stage?
Well, I don't need,
only in a speaking note?
I don't need to rely on it. The fact is that there was no deportation. And there was no recommendation made by the magistrate.
So you're withdrawing this point?
I am, so that we don't spend too much more time on it, my lord.
So we may assume he was convicted?
Yes, my lord. For the earlier proposition that submission I was making, that there is a distinction between 40 and 41. It is only the Governor General that can make the that can authorize the detention or make a deportation order under subsection 4. I rely upon the two cases of Jean Charles, which is to be found,
Sorry, this is in support of which
the
proposition?
submission that the respondents argue that the detention was lawful
Yes.
because the detention was delegated by the Governor General
I see.
to the minister.
I see.
And there are two cases which were in the Supreme Court and in the Court of Appeal. Jean Charles, and Marie Taylor. The reference for Jean Charles. It's Jean and Minister of Labor. That's to be found at EB Supplemental Authority 374. And also Taylor at EB Supplemental Authority 518. And a short quote from Justice Gonzalez-Cebola there, to the effect that, quote, and that's to be found at page 520, the Governor General was no mere rubber stamp. It was required by section 37(1) of the Act that the power confided to the Governor General be actually exercised by him to authorize them.
Which paragraph are you reading? 12. 12.
Yes.
Okay.
It was required, I had held that the exercise of that power was neither achieved nor signified by the declaratory words of that paragraph of the deportation order appearing immediately above the signature of the minister. It is recommended that consideration be given to the formulation of a separate independent order of deportation by the Governor General, which does not appear over the signature of the minister making the deportation order, formally and unequivocally exercising the power of also authorizing the detention of persons in respect of whom a deportation order is made by the minister. The result of the deficiencies in the document relied on as constituting the authority under which the applicants were detained was that there was no lawful cause of detention was shown in the return, and as Justice Blake said in Jean's case, that's the Jean Charles case referred earlier, all the authorities go to show that when drastic powers are given to interfere with personal liberty, there must be the strictest compliance with the letter of the law, be the person affected a subject by birth or naturalization or a stranger within the gates. And looking for the deportation order. 603. And if your lordships go to EB 603, there is an example of a deportation order that was made in respect of Mr. Ngumi in 2001.
This is in the original bundle, 603.
Yes, EB 603. And one will see at the bottom, just above the minister's signature, now therefore be informed that the Governor General, under the authority of Section 40, subsection 4 of the Immigration Act 1987, has authorized you to detain the said Douglas Moses Ngumi, a Kenyan national, in custody until such time as he can be placed aboard a ship or aircraft about to leave the Bahamas.
And just to check, Section 39(1) of the 87 Act has become Section 41 of our Act, is that right?
Yes.
The minister is designated by the Governor General to signify the exercise of the power by the Governor General.
Yes. And both Jean goes about 7 or 8 pages debunking the idea that the Governor General is a mere rubber stamp, which the minister can just exercise powers on behalf of. And I read the quote from Justice Gonzalez-Cebola, which was quite specific about it, just knowing it was very short.
So the Taylor case, the Gonzalez-Cebola case, is 1986.
Yes, my Lord.
So was any change made
No, my Lord.
to confer, to delegate power to the minister?
No, my Lord. Not that we have been able to find. I don't know if my friend has found any.
So, See, so you say that what appears on page 603 is ultra vires. The Governor-General had no power to designate a minister to make the decision.
Well, I'm not saying that there couldn't have been some way that the Governor-General could have delegated that power. I'm saying the minister can't assume unto himself and simply say that I am hereby exercising the powers of the Governor.
It doesn't, on page 603, that's not what it says. I mean, signed by the minister. It says Minister of Labour and Immigration, the minister designated by the Governor-General to signify the exercise of the powers conferred on the Governor-General by section 40, subsection 4.
But when you look at subsection, what is now 41.4.
No, but that's not the point. It's not saying that the power to designate is derived from that section. Those are the powers which are have been delegated. It doesn't say what the power to designate, what the Governor-General's power to designate is there, but it's assuming there is a power. So you say there is no such power, and certainly not in, I think, in any part of the Immigration Act we've seen, but you say that there is no such power, either express or part of the constitutional arrangement.
Yes, that's my submission. And finally, I would simply end with that by simply making the submission that there was no recommendation for deportation under Section 40, even if there was a power, my lord.
And this turns on the wording on the sheet.
Yes.
Might I just be clear too, please? Page 603, this is a deportation order dated when precisely?
This is 2001, 19th of November.
19th of November 2001.
Yes. But it's not relevant to, this is an example.
But there's no other, your submission is that there's no deportation order that was ever actually made here at any relevant time.
And there's no deportation. Sorry, go ahead. I interrupted you.
After this initial detention, there was no deportation order.
Correct.
And so you say that 3-month period, we never get into that.
Yes. And you will not find in the record either a deportation order or a detention order of any sort. You will find in the subsequent pages custodial orders and temporary custodial passes, etc., all of which refer to a Regulation 19, which simply doesn't exist in the immigration regulations.
Well, I understand that the submission made against you is that under the second half of subsection 4 of section 41, the statute requires detention unless there is a direction to contrary effect.
Yes.
But I think we've covered that ground.
Okay.
Yeah.
So, and I did make the submission that even if we're wrong on all of those points, that, or if I didn't, let me make it now, even if we're wrong on all those points, the period of time that the trial court or the Court of Appeal ought to have looked at was the period of time it would have taken the Governor-General to decide
Yes, you made that point.
whether to appeal or not. And then...
Well, sorry to just pick up on that. I would suggest it's the period of time for the minister to decide whether to make a deportation order under Section 41, and then for the Governor-General, in the light of that, to decide whether to authorise detention. It may not have been very long in either case, but it goes back to the point that I was raising with you, that for the Governor-General to have a power to authorise detention, he needs in place a deportation order, doesn't he? Under Section 40, subsection 1.
sorry. Yeah, so with respect, my lord, I would suggest not, because under subsection 4, it is the Governor General that makes the decision to make a deportation order, not the minister.
No, it's the detention order.
Oh, the detention order.
So what my lord is saying is that in the first limb of subsection 4, first of all, the deportation order has to be made. And once that's made, the Governor General can authorise detention.
Yes, I see that point.
Right. So it was a small point, probably doesn't make a big difference in terms of the time in fact, and very much difference in terms of your submission, but it's just to note that if there is a detention under the second limb of section 41.4, it's to allow other things to happen. 2 other things have to happen, not just one. In a case where there isn't an extant deportation order, the minister needs to be able to consider whether to make one. If he does, that closes the Governor General with the power to authorise detention.
That's under the first limb of section 41. Yes, and what? And the next point that I would like to deal with is the reliance that my friend, I think, for the respondents, is intending to rely on Lumba and Kambadzi. And this is, we take objection to my friend or the respondents mounting this argument. It's a completely new argument that Mr. Ngumi's detention was unlawful and only nominal damages should flow. If the detention would have happened anyway.
Sorry, where is that argument advanced in the respondent's written?
It is not advanced in the respondent's notice. My friend sent us the 2 cases last week and indicated he was going to rely on it for this new argument.
Well, speaking for myself, I wonder whether the most productive way might be to wait and hear what he has to say about it, because you don't know what his argument is yet, and you can come back and reply.
Agreed. So turning to the issue of assault and battery, this is ground 2 of the case. In short, we say that when Her Ladyship, the judge of first instance, made the award, she did not, as she ought to have, included or expressed an element for assault and battery. And we say that we submit that if there was an element of damages for assault and battery in the award, it ought not to have been tapered, because damages for assault and battery are not tapered, only for false imprisonment. And although, at first instance, similarly as we had done in Merson, and which was upheld by the Privy Council in Merson, one award could be made for false imprisonment, assault, and battery. But in this case, instead of at the end looking at an amount and perhaps discounting it for the present value of the purchasing power of such a lump sum as is done in personal injuries and discounting an amount, that was not done here. Her Ladyship simply took the amount that was awarded for false imprisonment, assault, and battery, and tapered the entire award. And the Court of Appeal did not deal with that argument, we say,
So you invited the court, didn't you, to make a global award reflecting both false imprisonment and assault and battery?
I did.
And false imprisonment awards are frequently tapered.
Yes, lady.
So what was your submission about tapering on the footing that you were inviting a global award?
Well, lady, I had advanced the argument that, I can't remember if it was, I did not advance an argument in the Supreme Court that there should be any tapering of the false imprisonment, assault and battery.
No.
Her ladyship, relying on tachytota, picked a very low figure and then proceeded to impose a brutal tapering on that rather than pick a figure in the round, so to speak, which would have been permissible, and then decide, well, instead of 700,000, I'm going to award a total of 500,000, which is what Justice, she was justice at the time, Sawyer did in Merson and in Tynes. But in this case, neither the Court of Appeal nor the judge provided any damages for the horrendous assaults which Mr. Ngumi was subjected to, which are listed in her judgment and set out in our case.
But if you had invited the judge to make a global award covering both the assaults and the false imprisonment, and you were aware, as you confirmed, that false imprisonment awards very typically are subject to a tapering mechanism, what alternative argument, if any, did you present to the judge as to what she should do, you having invited her to approach both on the same basis, if she decided in a relatively conventional way to introduce a tapering mechanism? What did you submit in the alternative she should do in relation to the assault in that case?
I didn't make a submission about tapering at all in the court at first instance. I had sought...
I'm so sorry. I thought you accepted that you appreciated that tapering was usual, or at least not uncommon, in false imprisonment cases when you were presenting your argument that a compendious approach should be adopted. So if you appreciated that, what I'm putting to you is, surely you must have appreciated that the judge might adopt an approach consequential upon your own submission, that there should be a compendious approach to assessment of damages, might adopt an approach which involved tapering. And if you didn't present any arguments that she shouldn't do that, in a sense, you were taking the risk that she might do that in relation to an award which some part of it would conventionally be subject to tapering.
At the time, my lord, my recollection was that I was arguing and submitting that she should do it on the basis as it was done in Merson and Tynes, and there was no tapering in those cases. I didn't invite her to taper. I fully expected that if she found a large figure on behalf of Mr. Ngumi, that there may have been a discounting of it for its immediate receipt. I don't recall making any submissions, and neither was I invited to or had any discussions at first instance on the issue of tapering. I'll have a look and see if that's the case. I don't recall having done that. So when we went to the Court of Appeal, and we are in fact appealing from the Court of Appeal's order, in which they simply said that they found no error in the learned judge making a compendious award of both. That's not sufficient to set it aside, although they could find no element of assault and battery in it. We say, since the Court of Appeal, we submit the Court of Appeal went and recalculated the damages afresh at the Court of Appeal, and set aside, I think, the $363,000 which had been awarded for false imprisonment, assault, and battery. The Court of Appeal should have found whether she was wrong, or when they themselves decided what the amount was, to include an element and express it for assault and battery.
The judge at first instance did identify the $386,000 as referable both to the false imprisonment and the assault and battery.
She did, my lady.
The Court of Appeal was entitled to proceed on that basis, therefore.
But they set it aside, my lady, as being inordinate.
Well, they set aside the amount as being too low, but
Yes.
not on the basis that it didn't reflect an element for
That's
assault and
correct, my
battery.
lady. They didn't. Yes. So. This is the Court of Appeal. So I deal with that issue at EB 232 onwards, EB 232 to 235 in the Court of Appeal. And I will simply refer your lordships to that so that I can move on to the next point, because I am running out of time.
Yeah.
Thank you.
That's a reference to your case, isn't it?
That's a reference to the actual submissions that we laid over to. It's repeated in our case, Lord.
Oh, I see. You mean it's the submissions you made in the
Court of Appeal.
So is that a reference to the transcript in the Court of Appeal?
No, it's actually our submissions. They appear under ground 3, damages for assault and battery. That's ground 3 in the Court of Appeal. At EB 232.
And what is this document? Is this a skeleton argument?
It is. These are the submissions, appellant's written submissions in support of appeal of quantum damages and basis of their assessment before the Court of Appeal.
Thank you.
It starts at 189.
Sorry,
Lord.
what's the reference again in EB?
It starts at EB 189.
Oh, but it's actually at 232.
Yes, and then the relevant portions are at pages 232 to 23, just the top of 235.
Thank you.
Thank you.
So we're not submitting that Her Ladyship or the Court of Appeal that it was inherently wrong for her to make a compendious award for false imprisonment, assault, and battery. But when she came to assess the level of the compendious award, she failed at any stage to reflect the damages for assault and battery because, and we say by logical implication, because she tapered the entire amount, which only happens in false imprisonment, not on assault and battery.
I understand that.
Yep. Taking now, if I may, the ground 3, I can take them together. Ground 3, damages for false imprisonment. Ground 6, the undue reliance on tachytota. And ground 8, the award of damages being manifestly too low. I think I can take them all together in the interest of time. We say, in summary, that the Court of Appeal erred in treating the low sum awarded by consent in the Court of Appeal in tachytota. Your Lordships will recall that, well, let me finish the submission. Firstly, in treating the low sum awarded by consent in the Court of Appeal in tachytota, after the matter had been remitted by the board for reassessment as equivalent to a guideline determined by the court, simply adjusting it for inflation. Two, they erred secondly in also relying on awards from other jurisdictions that were not cited to the court and in respect of which no submissions were heard, and failing to take Bahamian authorities into account.
Do you go so far as to submit what an appropriate overall global award should be, or what?
Sorry, I didn't hear.
Do you go so far as to submit what an overall global award should be?
Well, my lord, what we sought to do,
Inordinately low, I understand your submission to be.
what we did, my lord, was based on the case of Arkari, the case of Tuzovic, and the case of Scott from the Privy Council, all of which cases urge the courts in the Bahamas to develop their own levels of awards based on the local socioeconomic conditions, etc. And both, particularly in the Court of Appeal and in our case, we set out the cases for false imprisonment and assault and battery where the awards were very high. Then we set out a middle ground, and then we set out the lowest grounds, and the lowest grounds are the Takitota and the Amashir and the Bojang. Yes. The cases are all referenced in our case. These cases we submit should have been considered by the Court of Appeal in order to determine for the Bahamas what would be an appropriate level to make an award for the false imprisonment, assault, battery. And to answer your question, my lord, we suggested the sum of $3 million or 6.7 years of false imprisonment. And we demonstrated that even if first of all, at the Supreme Court, I did say it would be fantastical and absurd to simply extrapolate the amounts given per day in many of these cases, because the award would go into the many millions. And looking at the case of Thompson versus Commissioner of Police, Metropolitan Commissioner of Police, in which a daily rate calculated equivalently for the Bahamas was about $7,500, which fell within the middle bracket in the Bahamas. And even if you applied an extreme discount or tapering to it of even 2/3, that would still come up to, I think, $12 million. And so the suggestion of $3 million, we said, would have been an appropriate amount for a 6.7-year false imprisonment of Mr. Ngumi. By Bahamian standards, and also by reference to even using, as it was suggested in the Arkari case and in the Scott case and in Matuzovic, that perhaps in the absence of Bahamian authorities or where you're looking for comparators, one can look at the personal injury awards and the guidelines, or look at damages awarded for false imprisonment in the UK. And the President, Sir Michael Barnett, in the case of Delano, in the Bahamas specifically adopted the daily rate, albeit for a short term of imprisonment. When he was a judge, not the president of the Court of Appeal. And so we say that the approach that the Privy Council, the Court of Appeal, yes. So, Lords, we set out in our submissions, in our case, all of the cases in the Bahamas that were in relation to longer periods of imprisonment. And in those cases, the daily awards were $500, $750, and another one $977, which was awarded by the current Chief Justice in the case of Martin Orr, which is to be found at EB 1384. And we say that it was appropriate, as was done in Arcari at the Court of Appeal. Your Lordships may recall when you reviewed Arcari that there was a chart that was prepared of all of the personal injury awards in the Bahamas, from which their Lordships at the Court of Appeal took some guidance in determining what the level of awards for personal injuries might be in the Bahamas. And so we sought to do the same thing, although we didn't prepare a graph or a chart. We simply bracketed them in the very highest, Tamar Merson, Harvey Tynes, and the very lowest being Ngumi, Takitota. And we submit that the Court of Appeal ought not to have adopted the case of Takitota as a comparator because of the consent judgment. We have no idea on what basis the plaintiff and the defendant may have agreed to that consent to $500,000. Unfortunately, the Court of Appeal did not reassess damages in accordance with the guidance by the Privy Council in Takitota when it was remitted to the Court of Appeal. And so the only way we say that it would have been rational and reasonable for the Bahamas Court of Appeal to give some guidance, to indicate what the policy was, as was done in Thompson, Commissioner of Police in the UK, or to assist practitioners, to assist persons in settling cases, is to actually approach, as we attempted to persuade them to do in the Court of Appeal, to approach the assessment of damages on a principle basis, setting out and referring to all the relevant Bahamian cases, not simply adopting Gouchard from the Eastern Caribbean, and I think one case from New South Wales, and Elkin, I forget which they were, but there were a number of cases which had nothing to do with the Bahamas, and which the appellants were not given, Mr. Ngumi was not given the opportunity, neither were the defendants at the appeal, an opportunity to comment on. And essentially, we criticized the Court of Appeal for plucking a figure out of the air and simply awarding the sum of $750,000. We don't know what constitutes that figure, whether it includes constitutional damages or exemplary damages. We're aware, on the advice of the board, that you can't have both exemplary and constitutional damages.
I think it does, doesn't it?
Pardon me?
I think it does include, I think they're clear that it does include that, don't they?
I'm not sure about that.
They say that they're going to look at it in the round. But before we go there, I mean, you say you didn't, and obviously you didn't have the opportunity of commenting on those other authorities in front of the Court of Appeal, but you have that opportunity now. Why do you say those cases are not in point so far as
in fact,
the level of overall damages is concerned?
There is an annex which is to be found, in which we dealt with all those points, my Lord. Annex is to be found to the second set of submissions we gave on Gishard. in the Court of Appeal.
Sorry.
Paragraph 98.
No, I'm talking about the authorities which they relied
Yes,
on.
Lord.
I see.
Yes, we went into detail in 503 as well.
So where are we?
EB 503, it's volume 2. Yes. No, it wasn't an answer to the...
And this is an annex to what? Sorry, it's headed annex, but I just want, what's it an annex to?
This is a post-judgment speaking note. And it appears to follow the judgment of the Court of Appeal. And I'm assuming it's some attempt to ask the Court of Appeal to reopen the case.
It was our application for leave to appeal, my lord.
Oh, I see. Right, thank you.
And
That's your application to the board,
to the board, to the Court of Appeal for leave to appeal
And, right.
to the Privy Council.
Where,
I've got it, thank you.
And that's to be found, it's an annex
I
to,
know, but why is this not in your case for the Privy Council?
it is, my lord.
It is it?
Yes.
Where?
Which one? It's a paragraph, I'm told, 102,
102.
and that's at EB.
I see.
Yep, EB 939, paragraph 102. Had the appellant been given the opportunity to make submissions on these cases, it would have been pointed out on his behalf that the Bahamian cases were more authoritative and relevant for the reasons given, and ought to have been considered and preferred. In addition, each of the cases relied upon was on their own facts and unsatisfactory precedent,
I see.
et cetera, et cetera. I don't have
They're
to...
not repeated, but the appellant will, as necessary, rely on
Yes,
them.
I see.
Yes.
They're sort of incorporated by reference.
Yes.
Right.
And it's found at page 503 to EB 503 to
Yeah.
507.
Yeah.
And 30. Yeah. Yeah, I got it. So, in summary, I make just a few submissions with respect to all the cases referred to by the Court of Appeal. The key points are: 1, those cases did not include damages for assault and battery. 2, the conditions of detention in all of those cases were not remotely comparable to the deplorable, inhumane, and degrading conditions which the judge found in her judgment at EB 133. 3, after length of detention, conditions of detention is one of the significant factors in the overall assessment of damages. In 2 of the cases, that's AXD, found at 1699, EB 1699, and Belfkin at EB 1728. The claimant was lawfully detained for a significant period of time prior to the period of unlawful detention. And there was therefore no damages for the initial shock of the detention. which, as the cases for short periods of detention show, we submit can be substantial. Five, no attempt to uprate for inflation was made, even though in the case of Ruddock versus Taylor at EB 1844, just as an example, dates from 2003, and was 18 years old by the time of the Court of Appeal judgment. And lastly, number 6, there was no uprating for the higher cost of living in the Bahamas. And we say, in summary, that these are not minor but material factors. And it was unfair of the Court of Appeal to have completely ignored the very principled and comprehensive review of all the relevant Bahamian cases from which to come to a proper principled assessment of damages. And I assume the board, it is not the board's practice to attempt to assess damages. It will be, presumably, if we're successful on this, remitted back, hopefully, to the Court of Appeal to reassess. And we would have an opportunity to properly argue the case. I mean, other than Taki Tota, which the board set aside the decision, I think, of $400,000. There is, so far, there's Amahir, there's Bojang. There are now quite a few other cases which are en route that have been tried, 2 of them by Justice Charles, in which her ladyship continued to adopt the 250 figure. And the registrar in one case has also simply adopted the 250 figure. And so the ghost of Taki Tota, despite what the board had said in remitting it back to the Court of Appeal for reassessment, the ghost of Taki Tota continues to haunt assessment of damages in the Bahamas and what amounts should be awarded.
Can I just check one point? The annex you referred us to at page 503 and following doesn't seem, unless I've read it too quickly, to refer to the Guizard case.
The Guichard case?
Guichard case.
No, my lord. We had done a complete note on the Guichard case. Because what happened was, at the end of the hearing, we were invited to make submissions on Guichard, and I'll take your lordship to where we did that.
So, sorry, when you say at the end of the hearing, the Court of Appeal gave you an opportunity to make submissions on Guichard?
Just on Guichard.
Right, okay.
And we... Yeah, but we actually made the submissions. Written submissions. 283. And those submissions are to be found at EB 283 to 311.
Yes, thank you.
In which we analyzed Guichard, and the Court of Appeal seems to have adopted the approach, and it's reflected in their judgment at, and I'll find the page, where, my friend will find it, where the Court of Appeal said, well, none of the cases of long detention have ever approached $1 million, and simply left it at that, as if $1 million is a magic figure beyond which an assessment of damages ought not to be made.
Paragraph 38.
Paragraph 38, thank you very much. ED 366, appreciate it. And let me go back. There is before I move to the next point. I would like to take you back to the 3-month period, my lords, to simply take you to a quotation that appears in the transcript. I did want to bring that to your lordship's attention on the issue with whether there was any evidence at all. And where is it? Yeah. Where did you put it in the statement?
I rather thought that the respondents accepted that there wasn't evidence in relation to the initial period. Certainly in their case, they're referring to things happening much, much later. They don't say there was evidence in the initial period.
They are arguing that the respondents are arguing that there were significant efforts made.
But much later.
Much later, my lord.
Yeah, so far as I could see, they didn't refer to anything, evidence of anything being done in the initial period.
They didn't. And I just wanted to hammer that in with the quote from Counsel 831.
I think there had been an interview in June 2011, but that was sometime after the 3-month period had expired.
Yes, my lord.
But within a year, I think.
831.
Sorry, 831, did you say?
Yes, the lady, I'm told it's 831. Yes, it starts at page 831, where at line 12, his lordship, the president says, what evidence, line 12 to 13, what evidence there were steps they took to deport him? And counsel for the respondent said, yes, there was no evidence showing any steps that were taken to deport him. And then his lordship goes on to say, why could it not have been done within 1 week or 1 day, etc. And as to that 1 week or 1 day, that fits in, thank you, with the submission we made in our case, that the period of 48 hours or thereabouts, because that's the time provided for under the Criminal Procedure Code, as to once a person is arrested, they must be brought before a court. The Governor General or the Minister needn't take more than a few days or a week, certainly not months, to decide whether to issue a deportation order. So going back now to the Brown 3. So I would like to make the following submission. I submit that in periods of long detention, such as in Mr. Ngumi's case, the board in Takitota left open whether it was always necessary to apply the tapering. And we submit that the board did not. At paragraph 17, which is at EB 1900, the board observed that, quote, ordinarily, unquote, tapering of the initial rate is appropriate.
Sorry, what page again?
1900, EB 1900. And we submit that this leaves open the door for potential tapering not to be appropriate in certain circumstances. In summary, we say that this kind of long period of detention if there is and the conditions of detention and the beatings and the elements of constitutional breaches, which are qualitatively different from torts, which the constitutional breaches really strike at the foundation of society when people are being treated inhumanely and degradingly, and are being tear gassed, and are being beaten for hours, and are being held in conditions where a detention center made for 50 people, which is housing over 500 people, and they contract diseases, the itching disease, and also tuberculosis, which he was put into hospital for 5 months after his release. These kinds of cases, if a tapering is applied, it almost says to the executive, well, the longer you keep somebody in, the less damages you have to pay. It should be the reverse, we submit. And it's especially, we submit, perverse if damages are assessed starting at a very low figure of, say, $250 per day, as opposed to many of the others that were available within Bahamian jurisprudence. And then you apply, as the judge did, a massive tapering to that.
But can you help me on this? Did the Court of Appeal apply a tapering approach?
They don't say whether they did or not. That's the difficulty with their judgment.
Because in paragraph 17 of Takitota, I don't read, it's Lord Carswell, I think, isn't it, saying that that you should necessarily start with a figure and then taper. I mean, what he seems to be saying is that for a long period of detention, taking into account any element of aggravation and so on, the court should find an appropriate overall figure. And taking account of the inhumane conditions and the misery and distress suffered by the appellant.
Sorry, I didn't hear you.
Sorry, so that what Lord Carswell, I think, is suggesting is that the court should determine where he says what they consider to be an appropriate figure to reflect compensation for the long period and so on. I don't read him as saying that the court should necessarily start with a figure for the initial shock period, as it were, and then extrapolate. I mean, what he says there is that if they do that, they should bear in mind that you would then taper it. But
that is one of the options. Right?
I mean, the overall message in 17 seems to be, for a long period of detention, a light on an appropriate overall figure which takes account of, for example, inhumane conditions and so on.
Okay, fine. Oh, yeah, there it is. Oh, I was looking at the wrong one. Sorry. I appreciate that, Lord.
Yeah.
Looking at, if I could make this submission, looking at the award of $750,000 for Mr. Ngumi, although, frankly, with all due respect to the Court of Appeal, there is very little analysis in the Court of Appeal judgment. It cuts and pastes swathes of the judge's judgment in the court below, and goes to very little, if any, effort to analyze any of the submissions that were made, which were principled, and which relied upon, I think, 15 more Bahamian authorities, and didn't in any way give guidance or assistance. I mean, I can see a Supreme Court plucking a figure from the air and saying, overall, here's 750,000. But when it goes to the Court of Appeal, that is, for all intents and purposes, our apex court in the Bahamas. Not many cases go to the Privy Council. And their judgment is, regrettably, doesn't hold much help or offer much assistance to the courts below, or to practitioners, or to the parties who are involved. There are literally hundreds of these cases going on, which I'll deal with exemplary damages and constitutional damages later. So, that's yours, Dorothy.
I mean, might it not be said that you do get some guidance in favour of applicants from, well, paragraph 39 of the Court of Appeal's judgment, page 366, because they say an award of 386,000 as a basic award for compensatory damages is inordinately low.
39 what?
Sorry, page 366 is paragraph 39 of the judgment. And it just seemed to me that you might criticise the specificity of the guidance, but there is some guidance being given by them. I mean, they've made a finding, in effect, in your favour in paragraph 39 to say a particular figure would have been too low.
They do.
They pick it up. In a sense, you read that with what they say in paragraph 60 to 62, because having said that they'll consider the figure in the light of the aggravated and exemplary damages, they then do that. I think this is where they do it. And they say at 62 that the figure of 750,000 for the 6 years, etc., of unlawful detention is appropriate. I mean, I don't think that in coming to that figure they can have forgotten about the assaults and so on, battery of your client. At any rate, that's what they're saying, and they couple with that saying that the figures that you were putting forward are fantasy land.
Yeah. But Lord, what they don't even include an element for aggravated damages. You remember when we dealt with aggravated damages, they said they would come back to that later. That was...
Well, if you look at 61, they sort of do, don't they? Because they say that they itemise. Yes, I'm not quite sure. I haven't done...
Well, but also, if I may say, in paragraph 62, they're looking at the figures from the Takitota case, which in present day value was 670,000 for both the compensatory and aggravated aspects of the claim for damages. So it's difficult to say that they've left the aggravated elements out of account in their own thinking. You might criticise them for not including sufficient compensation for that, but it doesn't seem that they've forgotten about it.
Yeah, but my Lord, if one looks at the second sentence, sorry, 1, 2, 3, the fourth line down, sorry, the third line, fourth line down, their lordships say 750,000 for 750,000 for 6 years and 4 months of unlawful detention is appropriate. They specifically make that award for unlawful detention, not for constitutional damages or exemplary damages or aggravated damages or...
I read that as being a rolled up sum, I must say.
And they refer to it as a global award in the last sentence.
They do, but in the previous sentence, I would submit they contradicted themselves by referencing it only to unlawful detention as being appropriate.
Well, I mean, the first sentence of 62 refers both to compensatory and aggravated aspects of the claim for damages. That's the Takitota.
Yes, but again, Lord, we see that the ghost of Takitota is in fact
No, I
the
mean,
abuse
that's their
judgment.
point.
Again.
Have their point.
And because what they do is they uprate it to the present-day value of 670,000.
Yep.
And quite incorrectly, and we make this submission in our case, that the judge took apparently judicial notice that the conditions at the prison where Taki Toto was held were worse than the conditions at the detention center. And there was no basis for her to make that assumption. There was no such evidence in the case. And that is not a notorious fact under, I think, the Evidence Act as to what you can take judicial notice of.
But was there any evidence about the conditions at the detention centre?
Yes, my
I
lord.
mean, beyond the battery and so on.
Yes, my lord. There was the toilets didn't work. The detention, they flooded.
Because Taki Toto contains quite a vivid description of the conditions
Yes.
in the prison.
Yes.
So with that description on the one hand and the evidence of the conditions in the detention centre on the other, the judge could make that comparison, couldn't she?
Maybe, Lord, maybe. I wouldn't say no to it. But, and I grant you that Taki Tota's evidence was far more descriptive of the conditions at Fox Hill.
Anyway.
We refer to it as Fox Hell Prison in the Bahamas, Lords, because of the conditions. But so going back to the point of tapering, as we point out in our case, in summary, following, and we set it out in detail in our case, following a lengthy detention over many years, all of the consequences of a lengthy detention flow from that. I don't have to read them out again. And we highlight the consequences that flowed. And in particular, I would refer your lordships to the letter that he wrote to immigration, just after his release. It's at EB 944. 394950. We don't have to go to it, but it's the letter. It's
Seems to be a submission, 944.
Letter to immigration.
Was the end of your, I think, the summary in your case, isn't it?
Yes.
Of all these points.
So I will find the reference and refer to it in reply because I'm running out of time. And so, in short, we say that in a case as horrendous as this, certainly one should not, if there's going to be any tapering, we shouldn't start with the lowest possible figure that was recommended in Taki Toto. One should start with a realistic figure, which has been alighted upon by the President in his former embodiment as a Justice of the Supreme Court, and which other judges have focused on at different ranges. And so, I completely agree, and I do not submit that one must simply take a daily figure, extrapolate it, and award that total amount. But it certainly helps to look at what the authorities are on daily rates and to look at what the authorities are on assault and battery and the constitutional damages, and to sort of guide the court in coming to a figure and then appropriately reducing it to make a global sum if they choose to do that.
But as I understand it, your submission here, in taking into account all the factors and arriving at a global figure, there is also the glaring error that no proper account was taken of the wrongful detention pretty much from the outset.
Yes.
In the light of your submissions on the first point. So initial shock, all of this, you say, has not been properly taken into account in arriving at a figure.
I do, my lord.
And things went from bad to worse.
Yes. I mean, reading Lumba and Kaczynski, in the UK, there is a raft of regulations and supervisory reviews and every 8 days or every 14 days. I mean, there's a host of opportunities and safeguards to protect the liberty of the subject. That doesn't exist in the Bahamas. And I would simply refer in the case, we refer to the case of Sewell, which is a case decided by our former Chief Justice, John Isaacs, not John Isaacs, forget his first name. And the case of Sewell, and it's annotated in our case, if somebody could find it for me, please. And in that case, the government conceded that all of the documents, which are repeated in Mr. Ngubi's evidence, and I can just give you the references. Sewell is 1547, EB 1547. So in Sewell, his lordship, it was conceded by the government that Regulation 19 didn't exist. And your lordships may recall in the transcript my engagement with the Court of Appeal in this case, 817, at 817, EB 817, where I raised as an oral Article 28 motion that the Court of Appeal, which was not considered by the Court of Appeal, which the Court of Appeal should take into account in the issue of exemplary or constitutional damages, where the government was still relying on fictitious, non-existent regulations. As was done, I could just give your lordships the references, EB 610 and 611.
It's not, I don't know what point you're making, which is directly relevant to the present appeal.
So the point that I was making, Lord, is that we criticize the Global Award for not taking into account the continued fictitious use of Regulation 19 documentation.
Was that in this case?
Yes, my lord. At EB 817.
Is this referred to in your written case?
Yes, my lord. I'll find it in the case. It's a footnote at EB 916.
So you're saying that this should have been reflected in the award?
Yes. One way or the other, either constitutional damages or exemplary damages.
Right.
And they look very formal and they look very impressive at 610, 611, 616. No, those are the custodial ones. 614 is an example of one, and it goes on and on. Don't I list them?
But I thought you had now conceded that there was a conviction.
Yes, but sorry, I misunderstand.
Well, this is about committal orders, isn't it? I thought you had now conceded that he was properly arraigned and that there was a conviction on his guilty plea.
Yes, but with respect, that doesn't relate to. If we go to volume 2, I'm running out of time. If we go to volume 2, for instance, at page 610 or 611, EB 610, EB 611, EB 624, EB 625, 628. I mean, there's a plethora of them in that evidence on the section before the court.
But I mean, he was being illegally detained.
He was.
I mean, that's what the award of damages is all about.
Yes, my lord.
Yes.
And we were...
And there was reflection of the seriousness of the circumstances in the grant of the constitutional damages, and then the overlap with the exemplary damages.
Well,
So I'm just not, forgive me, I'm just not quite sure what point you're making.
Okay, so I'm still on the global award, and let me finalize the global award on this point, is that when, under our case, we refer to the many Bahamian authorities that we relied upon to show that exemplary damages or constitutional damages should have been a lot more than the 100,000 ordered or included in the Court of Appeal order or ordered by the judge. Because, as the cases reflect, notwithstanding judgment after judgment, the executive branch doesn't do anything to amend the law, continues to defend the indefensible, doesn't monitor or supervise who is in custody, hence Mr. Ngumi having been lost for 6.7 years at the detention center. I mean, we submit that an award of 750,000, it's about 750,000 does not in any way, if we look at exemplary and punitive or constitutional, does not deter or in any way set an example for the executive. It is simply paying lip service to the idea of freedom and constitutional rights when a person like Mr. Ngumi is subjected to the kind of torture, forced labor and servitude, beatings, conditions in which he was held for such an extended period of time, under no supervision by the courts, and simply released when we issued a habeas corpus. There was nothing to defend. And we rely on Innis versus the Attorney General, and that's at EB 180. So I'm short of time. Let me try and deal. 1810.
You are very short of time.
Very short. So,
and we do have your case on some of the small
yes.
items.
Yes.
In particular, we have them on your case on interest and costs.
So, Your Lordship has my case on costs. There's nothing much more that I can say
We
on that.
understand the case on costs.
Yes. And the interest, Mr. Ngumi detailed that in our case as well. He should receive compensation from day one. Whether it's at 6.25% or some lesser amount, in the Bahamas, the cases differ between 2%, 3%, 4.5% from the date the cause of action arose up to the date of writ. In this case, the Court of Appeal found that her ladyship was in error in deciding that the Rate of Interest Act didn't apply because this was not a personal injuries case. So they awarded interest at 6.25% from the date of issue of the writ. But there's no rational reason, there's no analysis why it shouldn't have been. It was an error of law on their part in not applying interest from the date the cause of action arose. So if there's anything else that I can address your Lordship's on, I think I've run through the case.
Well, we've troubled you at great length on numerous questions. Thank you very much, Mr. Smith.
Thank you, Madam.
Mr. Strang.
Yes, my Lord. I'll take it in the same order, at least to begin with, and start with the 3 months period. And I should preface it by saying that I accept that the judge in the Court of Appeal went wrong in missing out the step of the second limb under section 41.4. And I'll just take a look at their findings. The judge's finding is at page 115. Perhaps we should just start the page before paragraph 32. Effectively, the judge finds...
Which page?
114.
114.
114. The judge found that Mr. Ngumi was lawfully arrested, and the first 2 days of his detention were lawful, although she found then that he was brought before the magistrate too late. So by the time he was before the magistrate, he had been unlawfully detained for 4 days. And then, as is with regards to the 3-month finding, this is her finding at paragraph. The finding begins at paragraph 33. He ought to have been deported as soon as was reasonably practical, as recommended by the learned magistrate. And that wasn't done. And she goes on to make her finding about 3 months at paragraph 117.
107.
117.
Sorry, thank you.
Sorry, maybe I keep swallowing my ones. Paragraph 43. That's the finding that 3 months would be reasonable. And at the end of the paragraph, you can see her finding as to what was the unlawful period. The unlawful period excludes 3 months, so I accept one reads that as a finding that the detention was lawful for 3 months. And the Court of Appeal takes the same approach. At 3-5. But before I get there, may I just, because there's an issue over whether the judge ordered detention or recommended it, at least that's been raised before your lordships. Before the Court of Appeal...
Well, sorry, just before you move away from this, I mean, the judge doesn't identify any evidence that would allow one to say that actual steps were being taken to arrange for deportation.
I accept that. That would be a requirement for lawfulness.
I'm sorry, so if you're accepting that taking steps is a requirement for lawfulness,
Yes.
are you able to assist us as to how much of this period which the judge found to be lawful was in fact unlawful?
Well, once one gets to section 41.4, which I'll come on to, you have to split it up into, I accept you have to split it up into 2 periods.
Right.
And the second period, detention for the purposes of deportation, comes in after a decision's been made under the second limb of section 41.4, whether to deport or release. So there are 2 phases, and that's what I say when the courts below missed out the first phase. That's what I mean by that. Shall I just go to the Court of Appeal's finding, then go to the section 41.4? Hopefully it will become clear. But in the court, before I go to the Court of Appeal's finding, I just want to show your lordships one point. This issue whether, as a matter of fact, the magistrate ordered deportation or recommended it. Before the Court of Appeal, it was accepted as a fact that the magistrate recommended deportation. That's page 196 in the appellant's submissions to the Court of Appeal.
Page 196.
21.2.
Yes. So in context, on the previous page, 195, the relevant findings that are not contested on this appeal were that. But it was, of course, argued before the Court of Appeal that that gave no basis in law for detaining the appellant, and further, there was no evidential basis for the finding that 3 months' detention was reasonable. And the Court of Appeal addressed that at page 353. Those are the judge's findings. And then over the page, paragraph 14, noting that there was no finding that a deportation order itself had been made under Section 40. And then the conclusions, after further citation from authority and from the judge and then from the Act, paragraph 17. So I accept there that's also a finding of law that upon recommendation by the magistrate, the authorities had a reasonable time in which to arrange deportation. And that at paragraph 19, the reasonable time can be deducted from what would otherwise be an unlawful detention. And then at paragraph 20, they go on to say there's sufficient evidence. 3 months. But I accept that the Court of Appeal are also finding that 3 months was lawful because it was a reasonable time in which to arrange for deportation, and that follows in law from the magistrate's recommendation. And as your lordships and your ladyship have seen, it's not quite as straightforward as that in section 40 and 41(4) of the Act. And, well, we've looked at this already.
So there was no deportation order made?
No.
So the maximum period of lawful detention would be the period allowed for a deportation, the making of a deportation to be considered?
Yes.
How long do you submit that period was?
Well, I couldn't say more than a few days.
Yeah.
I have to accept that the Hardy L. Singh principles apply to the first phase, to the second limb under section 41(4).
But it's slightly different from Hardy Singh, isn't it? Because Hardy Singh is about actually the immigration authorities properly seized of the matter, actually arranging the deportation. Whereas I think that you're accepting that in order to justify continued detention, the immigration authorities, by which under the Act is meant the minister to make a deportation order and then the Governor General to authorise detention, have to be asked to take action. The recommendation by the court is only buying time for that process to occur. If I understood correctly,
what I'm saying under the second limb of section 41(4), the lawful authority to detain after a recommendation is for the purposes of a decision.
And that's a binary decision, as I read it. It's deportation order, detain, or release.
So it appears.
I mean, if no deportation order, there must presumably be a release.
Yes.
If there is a deportation order, then it's detain or release, but no, there's nothing else.
Well, strictly speaking, then one's under the first limb of 41(4), where there's a discretion, because it's may detain rather than shall detain, under the first limb of section 41.
Yes.
But may I ask this? In the light of the picture that we have of absolutely no action having been taken, how can it be appropriate at this level now to sanction even a few days? I mean, it appears that nothing at all was done at any level beyond detaining him.
Well, it remains the case that he was lawfully, well, I'll get on to why. Assuming he was lawfully detained upon the magistrate's recommendation, remembering that it's mandatory, then, as I say, the authority to detain Mr. Ngumi was for the purposes of a decision. And accepting the principles that underlay the decision in Hardy L. Singh, that decision would have to be taken within a reasonable time. And after the expiry of a reasonable time, detention would be unlawful under the first limb.
But may I just pick up on one point? If you could kind of assist me on this, the reasonable time presupposes that steps are being taken to consider whether to make the order or to put it in hand. And we have no evidence that any of that happened.
That's yes. That's.
Would it not follow, if that were to be correct, would it not follow that although notionally he had to be detained, he should have been immediately released?
I suppose applying the Hardy L. Singh principles, if one is immediately aware that no decision is going to be taken, the authority to hold might fall away if you apply the Hardyal Singh principles in the same way. But here we have a situation where detention is mandated by the Act. So there's a distinction there. And I accept it's difficult applying the distinction in terms of deciding for how long detention was lawful, where it appears by mistake nobody understood that a deportation order was required from the minister. Then,
I mean, I suppose strictly, although it's referred, if this is the right interpretation of section 41.4, second limb, and that the recommendation is by the magistrates, it's referred to as a recommendation, but its substantive effect is that the magistrates are making an order for detention, if this
yes,
interpretation is right. So that's a court order authorising detention. I suppose if nothing is being done at all pursuant to it, it becomes, well, very, very quickly unlawful, and the right to liberty could be vindicated by an application for habeas corpus.
Within a day or two, I suppose.
Within a day or two. But that then would suggest that it's unlawful detention for the purposes of forced imprisonment within a day or two as well, wouldn't it?
Yes, I would have to accept that, yes.
The strange thing, although we're proceeding on a rather hypothetical common assumption in the Court of Appeal that the magistrates did recommend deportation, actually what this charge sheet says is that they made a deportation order.
Yes.
It may well be the ministry didn't think there was much else they had to do apart from actually deport him, but of course they didn't do that
maybe we should have a quick look at that, because it appears to me that note is taken by an immigration officer. It says the signature ends.
Would you remind me the page?
It's 598.
Thank you. Yes.
The signature ends with a signed name, then I.O. which is immigration officer. As you can see from the middle column at the top, where the witnesses are described as IOs.
Yeah.
So I wouldn't take this as direct evidence of the magistrate's idea of what the magistrate decided.
Well, this is a bit difficult. This is a second appeal, not a fact-finding hearing.
I'm only raising that because this is now relied on to go behind the Court of Appeal and the judges that the magistrate recommended.
It was accepted as being a recommendation.
Yes.
Yeah. Yes. Well, I mean, yes, right.
I would say also, if the
I'm sorry, I
magistrate...
perhaps shouldn't have raised it, but I'm just asking myself what actually happened on the ground, bearing in mind that there's no evidence that anybody thought about whether a deportation order needed to be made, and even if one did, nobody seems to have done anything about getting him deported.
Yes.
There we are.
Just on the magistrate point, I would say as well, if the magistrate did utter the words, "You shall be deported," or "I order that you shall be deported," and the magistrate didn't have the power to order deportation, but did have the power to recommend and that decision that Mr. Ngumi ought to be deported, be read as a recommendation.
Yes. Thank you. Well, we'll resume at 2 o'clock.